Good afternoon, everyone. We're going to get started again so that we are on time here. It's exactly 4 o'clock. Can everybody hear? Okay, this is on. Okay. So, hello, my name is Arcelia Hurtado. I'm the Director of Policy and Training at the Prosecutors Alliance, an organization that activates prosecutors and their allies to improve the effectiveness, the fairness, and compassion of their state and local prosecutorial systems. And no, we do not support Prop 36. We do have a C4 arm, and so we are essentially an alternative to the CDAA in California and now in other states. We also have chapters in law schools, so if any of you students out there are interested in joining a chapter, please talk to me. So I'm honored to be here at Berkeley Law, my alma mater, to introduce this important panel and the esteemed speakers and moderator for the panel. So one of the greatest threats, I believe, to modern democracy is the increasing politicization of the discretion that prosecutors and judges customarily exercise in the course of fulfilling their duties as elected representatives of the people. As local prosecutors and judges have begun to reconceive their role and embrace criminal justice reforms, opposition forces have moved to interfere with their use of prosecutorial discretion through preemption. So you may all be familiar with recall efforts here in California, but of course it's not a phenomenon, as you all know, unique to California. According to the Local Solutions Support Center, as of January of 2023, at least 28 preemption bills have been introduced in 16 states to undermine anti-carceral uses of prosecutorial discretion, and more are being introduced every legislative session to undermine both judicial and prosecutorial discretion. So this important panel will discuss this disturbing trend and what it means for the integrity of our democracy. So now let me introduce the panel. So Alameda County District Attorney Pamela Price is a Yale and UC Berkeley law grad. Go Bears. She was elected in 2022. Prior to her election, she built a successful law firm, coordinated legal teams nationwide, and argued a landmark racial harassment case before the Supreme Court. A survivor of domestic violence, she prioritizes safety for victims and their families. Sherry Boston is the district attorney for the Stone Mountain Judicial Circuit since 2016. She is one of the few African-American women in this role nationwide. She oversees felony prosecutions and leads initiatives addressing gun violence while playing an integral role in national discussions on juvenile justice, reentry, and accountability reform strategies. Erwin Chemerinsky, Dean of Berkeley Law since 2017, is widely regarded as one of the most influential figures in legal education. Previously, he was founding dean of UC Irvine Law. He's authored 19 books and over 200 law review articles, regularly writes for national publications, and frequently argues cases before the U.S. Supreme Court. Rachel Marshall is the executive director of the Institute for Innovation and Prosecution at John Jay College in New York City, promoting prosecutorial reform and community-centered approaches. Previously, she served as communications director and policy advisor for the San Francisco District Attorney's Office, where I had the enormous pleasure of working with her, and spent nearly a decade as a public defender in Oakland. And finally, last but not least, the moderator for this panel is Rebecca S. Goldstein, an assistant professor of law and political science at UC Berkeley. Her research examines the interplay between politics and the criminal justice system using quantitative methods, focusing on policing, incarceration, and monetary sanctions. She earned her PhD from Harvard University in 2019. So please join me in welcoming the panel.
Thank you so much. It's wonderful to be here with this really distinguished group of panelists and all of you. So on the theme of the day, this panel is about the use of prosecutorial discretion and the way that it's being attacked and criticized from a lot of different fronts. So I wanted to start by asking the real-life prosecutors we have on this panel if they could just start off by telling us, and you can go in either order, if they could just start off by telling us about some examples of times they've used discretion, perhaps in creative ways, in order to further their goals of criminal justice reform, reduced incarceration in jails and prisons, and feeling like they've been criticized or scrutinized in ways their more traditional predecessors or more traditional counterparts across the country would not have been criticized for similar uses of discretion.
I will go first. So I kind of wanted to reframe this question a little bit because I think we should really talk about something that State's Attorney Fox really pointed out well in her keynote speech, which is this idea that prosecutorial discretion is something new and that it's something unique. It is 100% the backbone of what we are asked to do. Our criminal legal system would be overwhelmed, as you know, if every case that was charged across every facet of the court system went to trial. There's absolutely no way that's possible. We know that on average about 10% of criminal cases actually go to trial. And so the question is, what happens to the other 90% of cases? Well, those cases are resolved in a myriad of ways. Some are plea negotiations, but many of those cases are reduced or dismissed using prosecutorial discretion. And prior to becoming DA and taking office in 2017, I spent 6 years as the Solicitor General in DeKalb County, which is the misdemeanor prosecutor. And so I was the elected that ran that office. And I always say when people talk about, this idea of blanket policies is new, I point to a piece of prosecutorial discretion that is being used in every small court in America, traffic court. Every day, I don't care where you go, if it's rural America or a city, if you walk into traffic court, there are going to be policies that prosecutor has put in place around traffic offenses. The idea of, we're only going to prosecute speeding cases that are 15 miles over the speed limit, right? What happens to the rest of those cases? There are policies that a prosecutor has decided that those cases are not worth pursuing. They would rather focus on more serious traffic offenses, like driving under the influence of alcohol or drugs or vehicular homicide, right? Not necessarily someone that is speeding a relatively low amount over the speed limit. And so I frame it that way because while no one will bat or blink an eye when it comes to those offenses, which in the state of Georgia are misdemeanors, it's when we start talking about other kinds of cases, whether it's possession of marijuana less than an ounce, which in Georgia is still a misdemeanor, or nonviolent property crimes that are felonies in Georgia. Then people want to say, well, you are abusing your discretion, right? Or you have to follow every law that the legislature has written. It's your job to rubber stamp. And I said, well, if it's my job to rubber stamp, then you wouldn't need me to be an elected official with a platform and ideas. You could just put somebody in this position whose job is to just push paper. But that's not the role that we play. And so I think it's important to frame this conversation around the idea that everything we do in every type of case we do is rooted in discretion and making policies that allow you to move cases that are not affecting public safety while you can focus on those cases, those crimes, and those persons that are committing crimes within your community that genuinely are potentially a harm to the people in your community.
I'm happy to jump in. I don't consider, I never prosecuted a case. I worked for CHESA, but I wasn't a real prosecutor. Madam DA, why don't you go first and I'll add in.
I wasn't a real prosecutor, okay. Well, putting it, the question that's posed for me as the elected district attorney of Alameda County clearly reflects the vortex that my community is currently in. I'm the first non-anointed, non-appointed district attorney in this county in 100 years. I'm obviously a Black woman, and that's very different from every one of my predecessors. And so everything that I do, what time is it? Everything that I do every day is scrutinized differently than my predecessors. So examples, again, what time is it? How much time do I have? I thought I would give 3 examples where I feel like I've used my discretion creatively, and Sherry is absolutely correct. The job has to involve discretion. I was elected because people trusted my ability to make decisions and solve problems. That's how you get elected. That's how we practice law. But now, in this season of this recall, everything that we've done is being questioned in ways that are absolutely different from my predecessors. For instance, in April of last year, we adopted 2 policies. One a little earlier, we did a draft in March, but we adopted a policy called Special Directive 23-01. It basically said that if you want to use certain enhancements, which Alameda County has a history of being very enhancement heavy in the prosecution of cases, and very racially biased in the prosecution and the use of enhancements. If you want to use an enhancement, there is a procedure. We will have a consideration and a request for certain enhancements, not all, but for certain enhancements, you will vet that with your supervisor, and then if the supervisor believes that it's appropriate, then that person can pass it to the next person up the chain of command. And if that person thinks it's appropriate, then it will go to the chief assistant. And if he thinks it's appropriate, then ultimately it will come to me. That has caused a total uproar in our community, as if no one prior to January of 2023 ever heard of enhancements. They literally act as if this is a new thing that I came up with, that the legislature had nothing to do with, that the Commission on Sentencing had nothing to say about, which has been a conversation or a discussion since 2017. But literally there were people, radio commentators and people on the radio saying, you know, what is an enhancement and how dare she interfere with the use of enhancements in her office. That conversation never happened before January 2023. Similarly, we adopted a companion policy with respect to the charging of juveniles and how those cases would be processed and considered. And that, again, caused a huge backlash and outroar because the supposition was that all juveniles should be tried as adults. And if you are not trying all juveniles as adults, automatically you are abusing your discretion, right? Which is exactly the opposite of using your discretion. One of the issues that we have in California is that because the law has changed, there are many juveniles who were tried as adults and who received these horrendous sentences from anywhere from 85 years to life to 200 years to life, 100 years to life, and those sentences are now deemed to be illegal. So those cases are coming back to the county, and in Alameda County, we have a lot of those cases because my predecessors believed in trying juveniles as adults and giving them enhancements and the harshest possible sentences. So we are now required to look at those cases again, decide should the person go to adult court, should they remain in juvenile court, and what is the proper disposition for someone who went to prison when he was 16 or 17 and is now 27 and really has not had a good opportunity to rehabilitate, or maybe they have. Each case is different. And so we have to use our discretion, and we created a policy that said, okay, we're going to look at these cases and we are going to exercise our discretion, but that became, the basis for the abuse of power claims that we've been subjected to. The third one was with respect to the use of outside counsel, which I thought was really strange and continues to be interesting, because I come from a private practice where I co-counsel with counsel all the time. It's a way of expanding your resources and ultimately getting the best outcome for the client. The district attorney's office has a long history of collaborating with the attorney general's office and with other district attorney's office. This is with civil litigation and the criminal prosecution of corporate criminals, which was not going very well, quite frankly. And so we expanded that unit. We were able to get the first criminal grand jury indictment of a major corporation and 2 corporate officers for environmental pollution. And we did that in part because we shifted our resources and we expanded our resources by co-counseling with outside counsel. That when that issue came before the Board of Supervisors, there were people in the lawyers who used to work in my office complaining to the Board of Supervisors that I was doing something illegal, unorthodox, and the board had to look at it. County counsel looked at it. She said, seems normal to me. Other offices have done it, in fact, but in Alameda County, it was such a big deal, and it continues to be a matter of controversy whether or not it's appropriate for us to actually engage with private law firms to assist us in the prosecution of civil cases.
That's so interesting. I wanted to just quickly ask a follow-up to the prosecutors here. What do you feel like are the most important sources of the criticism that you're talking about? Do you feel like it's the public and the press, your line prosecutors who work in your office, county officials, city officials, state-level officials, or kind of all of the above?
It's the politics more than anything else. I will tell you that in all of the initiatives that I have rolled out and the decisions I've made, I generally have the support of my law enforcement community, my board of commissioners, the greater community. I mean, there's always exceptions. There's always going to be a voice of dissension, but I have found that the criticism that has come have been from people that don't live in my community, don't vote in my community, and have honestly a thought that the voters of my community are not capable of making decisions for themselves. And that's the issue that we face. So my criticism comes from the Republican legislature and the Republican governor and the Republican attorney general. Now, the attorney general does happen to live in DeKalb County. But I can tell you this, I have never heard him complain about any issues directly in his neighborhood. He's only had things to say when he's down at the Capitol with all of his friends. But on the other hand of it, he is very happy with how things are going in the community in DeKalb County that he happens to live in. So I think that when you have, and in our case, government officials like our governor who said that they were looking to create a commission to address the rogue prosecutors, that's how he described it, that are in Georgia. And so this idea of labeling prosecutors as not being law and order and as creating policies that are harmful to communities and misstating and spreading misinformation and disinformation about the work that we're doing, and that we are causing harm to a community. And the greater public doesn't really have an idea. So when they hear, for instance, a governor say, this particular prosecutor got a not guilty in a murder case, as if that has never happened, and as if it won't happen again, as if it's not equally happening to colleagues that operate any differently than me on the other side. We are not in a profession where we are going to gain convictions on every single case. And there are plenty of cases that will go to trial and be lost because a jury has made the decision that we didn't prove our case beyond a reasonable doubt. That is what we are required to do. But suddenly it has become a measurement and metric of success, but only for certain kinds of prosecutors. So I think it depends everywhere, but in my jurisdiction, it really is the politics and voices of folks that don't live in my community.
Can I jump in to add to that a little bit? I think something that you said I really want to follow up on, which is the scrutiny that happens when you have a reform-minded prosecutor in office is what is so misleading to a lot of the public. Because as we've talked about, the public doesn't have a great understanding of what's happening in your everyday criminal case. And as DA Boston just said, they don't understand the conviction rates or what happens in a typical case or dismissal rates. But as soon as there's sort of that nonstop target on a reform-minded prosecutor, which we know happens from pretty much the day they take office oftentimes, then it suddenly distorts the picture and creates a reality that's not actually accurate. And so, and just to give a concrete example to that even is, during my time working for DA Boudin, there was this perceived crime wave, particularly around shoplifting and a lot of different kinds of crimes, where that was completely divorced from the reality of what had been happening in San Francisco for a long time, where a lot of these kinds of crimes had been really common for many, many years, if not decades. And yet, because there was such a focus on DA Boudin, that distorted the picture, so to the point where you had a crime happen. Many of you may have seen this viral video where there was a break-in in a Walgreens that was caught on video, and a reporter, an actual reporter, tweeted it out and wrote #no consequences. Now, the person hadn't even been arrested. The case hadn't made its way to our office. But that distortion, that misleading sense of what's reality, really can create this false picture and this false sense that reform-minded prosecutors are using discretion in ways that are unwarranted or inappropriate. And that couldn't be farther from the truth. And we see that over and over again because, of course, once the recall succeeded in San Francisco, we didn't see crime stop. We didn't see these crimes go down. In fact, we actually saw the opposite. But the scrutiny had stopped. And so all of a sudden, the narrative changed significantly because there wasn't, when we saw the same kinds of crimes happen, whether it was big break-ins and smash and grabs and all the same kind of things that were really blamed on DA Boudin because of his reform-minded approach in San Francisco, when they continued after he was gone, there was just no attention to it. And when there was, it was never about the prosecutor because she spoke differently. So I think the scrutiny really creates a distortion that feeds into the public, who I think sometimes just don't know better because they're not really aware of the ways in which most prosecutors approach their cases. And it's why some of this transparency and education around the way that the system works is so critical. And that's one of the things I know we're trying to do on the ABA task force for prosecutorial independence, is really trying to educate the public about the importance of what prosecutors do, how they make decisions, and really putting it all in context so that we don't get this misleading picture that really leads many in politics, but also in the public, to have a misunderstanding of what reform-minded prosecutors do versus other kinds of prosecutors. So I just wanted to add that.
Yeah, of course. And DA Price, did you want to jump in about the sources of criticism for?
Sure.
Yeah.
I mean, I would say, yes, the folks kind of, after DA Boudin left, they calmed down, and then they jumped across the bay. We're right across the bay, okay? They were like, oh, she won. And so they literally flooded my community with media misinformation. Every attack that they had honed, that they found worked in San Francisco, they brought it over here. And you're absolutely right. Our community was not prepared because they had never covered the district attorney's office in the ways that we were covered. The kinds of data and information that we were asked to produce, like, you got to tell us this, tell us this. The CPRA, California Public Records Act request went off the charts. They had never done that. And, my director of administration, vice operations person is here, and she experienced that. She was able to reassure us the kinds of information that it took my predecessor years to produce. The expectation is that we would have it next week, okay? And so it really was quite unreasonable and very distorted, to the point of the media misinformation Media misinformation and malpractice is what we call it, because the misleading of the public has just been so shameful. And often we would watch for the last year, you can see the coverage that is given to me and the scrutiny. And so there are people in my community that think there are actually 2 district attorneys. Because sometimes when we do something good, when we get a verdict or we sue somebody or we settle a case, it's the DA's office. When it's something bad, it's that DA Pamela Price. And they literally split me away from the office and have attacked me in ways without recognizing you are undermining our administration of justice. And I won't say they don't recognize it. They literally don't care. And so, yes, it was San Francisco. Our media is market. We're in the San Francisco media market. We don't have local media with one exception. Our major newspapers are San Francisco Chronicle in San Francisco, and then the coverage comes out of San Jose. And so the East Bay is always getting, really mischaracterized what is happening here. And to the misinformation and misleading, they labeled me the DA of Oakland. And then, as they attacked Oakland, everything bad that happened in Oakland, from every car break-in, every business closing, every carjacking, every home invasion, every robbery, everything that the police said was going wrong, they said, oh, that's the DA's fault. The consequences. She's the reason why we can't arrest people, because the DA, and as one of our congressmen famously said, the police catch and the DA releases. And people don't know enough to know I don't release anybody, right? It's not not within the scope of my authority. There's something called a sheriff, and there's also something called a court. But they got written out of the equation as the effort was politically driven to make me the problem.
And I forgot to mention, when the reporter tagged #NoConsequences, the key part was she also hashtagged Jason Boudin. So it was blaming him before a case had even made its way. So it's exactly that sense and that misleading effort by many in the media, I think, particularly in local media, to perpetuate those narratives.
Wow, thank you. One thing that I've written about a little in my own work is trying to just tease out the distinction between public backlash, even when it's due to kind of what you are talking about as sort of media manipulation or mischaracterization of what's going on, but backlash that's basically coming from the public in some way. And I think what DA Boston was more talking about, which I'll do the obnoxious law professor thing and cite my own term that I coined, which I've called toplash, which is kind of backlash, but coming from these state level officials rather than coming from the public. And I just wanted to bring Erwin into our conversation here and ask a little about what you think sort of the consequences for the democratic process are of sort of both of these different types of critique of elected prosecutors.
Sure, let me try to answer your question in a slightly broader context, because I obviously agree with everything people have said, and yet I bring a different perspective. My field's constitutional law, and I believe in checks and balances. And so when I think about prosecutorial discretion, I wonder, okay, how do we have checks and balances when it comes to prosecutorial decision-making? So let me make 3 points, then I think my third touches on what you're going to say. One is, I do think we need to have checks on prosecutorial discretion. Trust me, it doesn't work ever when it comes to people who exercise enormous power. Sometimes there's prosecutors who commit egregious violations of the law. I lived in Durham, North Carolina, when a prosecutor there, Mike Nifong, literally fabricated evidence to keep a case going when it should have long ago been dismissed. He was rightfully disbarred. But those are the rarer instances. I think there are a lot more instances where prosecutors internalize their role and may end up violating rights in the context. Now, it's almost 25 years ago, after the Rampart scandal came out in Los Angeles, I was asked to do a study of the criminal justice system. And one of the things that I saw time and again is in instances where there was serious police misconduct, fabricating evidence and lying in court, the prosecutors who knew what was going on didn't speak out about it because they didn't see it was their role to do so. Or I've handled a number of criminal appeals, including some death penalty appeals. And what's characteristic of almost all of them, and certainly the death penalty cases, is egregious Brady violations. And I wonder, why does this happen? Because these are well-intentioned individuals for the most part. Well, social psychologists tell us that role very powerfully affects behavior. And I think people in prosecutorial roles internalize what their job is, and though it can be articulated as doing justice, it's often seen as gaining convictions. My oldest son spent 10 years as an assistant U.S. attorney, and I watched how much he came to embody a certain view of the criminal justice system from the prosecutor's perspective. I'm sure he never did anything that violated the law or the rules, but I could certainly see how much role affected his behavior. So that leads to my second point. I think often there are no checks on prosecutors in the criminal justice system. Again, let me tell a story and then refer to an example that's already been mentioned. When I was living in Orange County, there was serious violations with regard to the district attorney and the jails in Orange County. So much so that the United States Department of Justice initiated an investigation, pattern and practice violation. And when a criminal defense lawyer raised this to a judge as part of a prosecution where there's no doubt there was serious misconduct, the prosecutor's office responded by then disqualifying that judge in 55 of the next 58 murder cases where the judge was assigned. Because in California, each side can have one peremptory challenge in state court of a judge. And the way in which the prosecutor's office went to intimidate judges was by just using this authority. And they did it 55 of 58 times in the next murder cases. Judge Goethals was assigned. I represented the Orange County Superior Court judges in bringing a challenge to this. And I lost in the California Court of Appeal 2-1, and the California Supreme Court denied review, saying that prosecutors have that authority. There was no check on their ability to do that. It was already mentioned in terms of plea bargaining. The actual statistics now are over 95% of cases are disposed of through plea bargains. Where is the check that exists on prosecutorial discretion in the context of the plea bargaining process? And then third, and this is where I get to your question, I think the political checks that exist are very problematic. We've already talked about the recalls that are used, the political removal of prosecutors like in Florida, the preemption statutes that are there. And what we know is that political pressure in the criminal justice system so often is in the direction of being harsher on crime. When's the last time a legislature adopted a law to expand the rights of criminal defendants? And so you're not going to see a recall effort directed at a prosecutor who's perceived as too harsh on crime. It's always going to be the other way, which then, to me, creates all the wrong incentives. So ultimately, Becca, where I come out is, I think we've got to find a way of limiting the political pressures that are put on prosecutors, but at the same time, we've got to create more institutional checks and balances with regard to prosecutors.
Wow, thank you so much. Yeah, that's so fascinating. And there's legal scholars who've written about the way that the criminal justice system operates almost as a regulatory agency for criminal behavior. And yet in our federal regulatory agencies, there's a very robust oversight process, and there's just very little for prosecutors. So that's a really, really interesting point about kind of the two directions there. The next question I wanted to ask is, and anyone can jump in, just they feel like they want to make a point on this one. So given this kind of really daunting landscape of scrutiny and criticism, what are the political considerations and maybe even the legal considerations that you are taking into account when you are deciding to use your discretion in ways that are perhaps more creative or at least just different than more traditional predecessor or counterpart might have done?
Well, I mean, here is the reality of it, and we're having a lot of conversations about, oversight and the need for checks and balances, but at the end of the day, this is we can't remove the politics out of a role that you have to run for every 4 or 6 years and choose a political party, right? So the reality of it is that it is an elected position, and as an elected position, the people have a right to know what you are going to do, what your value set is, where your priorities are. That's the backbone of the role. And are you going to be transparent? Are you going to use data analysis? Are you going to have public-facing dashboards? We can't run away from that. But at the end of the day, now, and when I talk about Georgia, who's instituted a commission, that even me sitting on a panel like this on Zoom and saying things that I either have a policy on or may not do subjects me to removal. And so that is always in the back of my mind now. I am carefully choosing my words and finding a way to convey to my constituents how I am going to use my platform to bring justice in our community without saying something that will put me in a position of defending myself and being removed. And in our state, the commission, once removed, you can't run for re-election for 10 years. It's a 10-year ban. So unlike in other areas where we've seen people removed and able to, run again, Andrew Warren and Monique Worrell both have won their primaries. They're on the ballot and their communities will likely re-elect them in November. But there are folks that are looking for ways to get around that. And that's what they did in Georgia, because they're like, hey, we're now seeing removal's the first part. The second step is, how do we prevent those communities from just putting that person back in office? Or even worse, how do we scare the person that comes behind them, their predecessors, from enacting and bringing in those same policies? Because that's really what they want to do, is change the landscape and force people to be silenced, which is effective because I have to be like, nod, nod, wink, wink, right? Or someone coming behind me is like, well, they removed Sherry, so we better not say or do any of these things because we're next.
And it can't be stated enough, and it's been touched upon a little bit today, that this is happening, particularly in the top lash context, where there have been elected prosecutors who are primarily women of color, but people of color more generally, and especially Black women. And where we see that part that DA Boston just talked about in terms of saying you can't run for office again for 10 years, that is literally disenfranchisement of particular communities that are saying you don't get to have who you want in office. And those are communities of color largely. And that is such a deep and systemic problem. And I see that through so many legislative efforts, both in Georgia, but around the country, because as Arcelia mentioned in the introduction, these are laws that these are attempted laws, and in some cases actual laws that are so prevalent around the country, where the majority of states have tried in some way to create some sort of preemption laws, but we know, and we can look very clearly at who they're targeting. Where you have, even for example, someone like Sim Gill in Utah, a state that doesn't get that much attention when we talk about reform prosecutors, but he's a Democrat in a very red state where they have passed a bill that literally audits every 15 minutes of his staff's time, that only affects Salt Lake City, doesn't affect the rest of the state, and clearly targeting him for his approach that is more reform-minded and adopts and uses a different narrative. But I think this is really about disenfranchising local communities, which is why this is so relevant to our conversations about democracy that I know a lot of us are having these days.
I'm sorry, I was going to say, even worse, we're seeing what's happening, and DA Price alluded to this. Now you have the narrative that people are saying, even whenever more conservative communities or people that are passing the litmus test, when they have an uptick in crime, what do they say? Oh, well, my neighbor, progressive prosecutor X or reform-minded prosecutor X, is not doing his or her job, and as a result, the people that live in that community have been coming over to my community, and that's why my crime is problematic. When the reality of it is that we all have the same crime numbers, right? We all do. But it's this idea that we're going to make sure that there is a distinction there is an exception for the people that are on our good list, right? And then there are violations for the people that exist on what they deem their no list.
Yeah, I mean, I think that recent sort of shifting of the blame from San Francisco to Alameda County is clearly a political strategy and a political narrative. Our community is definitely at risk of being disenfranchised because the people voted in November of 2022, and by January of 2023, people were trying to overturn that vote. And so we are now here because a few billionaires had enough money to pay and spend $3 million to basically take away the vote of this community. As the district attorney and as a new person to this role, one of the things that I really strive for is to I really strive to keep politics out of the office and out of my decision making. I will not make decisions based on political considerations. Having said that, I am an elected official, and so I am understanding that I need to engage with my community. And so it's a balancing act, and it's a line that I'm learning to walk, quite frankly. How do I practice law in a way that I understand is ethical and has objectives to reform this system and deal with the political wrath of the people who are coming against us? And so our position has been keep the noise outside. We have to do our job. You know, we get a lot of attacks and a lot of heat because they'll start talking. There's a lot of buzz about cases that I, as a prosecutor, cannot talk about. And also, you talk about double standard. You know, prosecutors traditionally have been expected to be advocates for victims and, you know, representing the victims and really, engaging with victims. And we had a case where I took a picture with the victim's grandmother, and the court relied upon that picture to disqualify my entire office, saying I had too many strong feelings about this particular case. So it's like you're damned if you do, damned if you don't when you're the political target. And make no mistake, the judiciary is not above the politics, unfortunately.
Could at least the people in this panel agree that structural reforms, eliminating the ability to have recalls or making them far more difficult would be a desirable thing to do, and eliminating the ability of a governor to remove a district attorney, that those things would at least provide some assurance? Doesn't obviously remove politics as an elected office, but it would certainly allow the district attorneys to do their jobs.
Yeah, absolutely. And I think your point is very well taken, that we should not have these political ways of undermining what we're doing on the outside, where the public clearly does not understand the challenges that we face or the processes or the actors or where the power lies and what we actually have to do day to day. I mean, I have been in the last year, the public actually thinks that I've characterized it, they think that I'm sitting at my desk with a big red phone, and every time somebody gets arrested, the police call me up and say, what charges should we bring? I mean, that's really what they think. They think I'm sitting there all tied to my desk, making day-to-day charges on misdemeanors, felonies, enhancements, everything. And it's like I've become this all-powerful, Wizard of Oz. That is literally a media characterization of the role of the district attorney. And to your point, however, it is important, and one of the things we have tried to do is to institutionalize checks and balances inside the office. We do have the legislative mandate or a foundation because we have the Racial Justice Act in California. And so we're using that to try to, train prosecutors and put restrictions around the abuse of prosecutorial authority. And that is the path that we've taken. And as a consequence, the prosecutors in the office who have never had any kind of checks or balances, they are having a very difficult time.
So I want to talk about something that the dean just brought up. And this is the underlying issue is, where is the balance between checks and balances and undermining the will of the people in democracy? And I think that's the conversation that is very difficult one to have. And I will as much as I get asked to speak about what's happening in Georgia, and for those of you that don't know, that I have filed a lawsuit against the state of Georgia, and we are litigating this commission in court. But I always, when I speak about this, I remind people that although this legislation was passed and signed by a majority of Republican legislators in both the House and the Senate, and then signed by a Republican governor and championed by Republicans, the legislation first started in 2020 by Democrats. And rightfully, and what I'll say, it all started with a little-known case, and I say that because y'all are going to know what I'm talking about, when we had a young man who was killed in South Georgia who was on a jog, Ahmaud Arbery. That's where the Democrats in the legislature, when it was discovered that this particular DA, Jackie Johnson, who one of the defendants had worked in her office as a DA investigator, and that she had participated, or when the police came to ask her opinions about charging, had basically said nothing to see here, until everybody in America saw the video and watched Ahmaud Arbery be murdered by 3 white men while jogging. So when the Democrats at that point said, this is it, we have to have a check on district attorneys who are not doing their job, they wrote the bill. And as soon as I saw it, I called my fellow Democrats and I said, I understand your motivations, but I'm here to tell you, in 2020, I know what the climate is like out here for prosecutors. This will not be used in the way that you intended it to be used, which are to hold district attorneys and prosecutors accountable when they are turning a blind eye to obvious crimes and murders in their community and not holding offenders accountable when someone is being killed in the streets to cover up and save their friends. And I said, this is not the way to do it. It will be used for evil purposes. And luckily for me, the Democrats listened to me and understood where I was coming from when I said there are district attorneys that are choosing not to prosecute misdemeanor marijuana offenses, and the legislators don't like that. You are giving them a vehicle to come after those people. And so they withdrew the bill, but you can't unring a doorbell. So the Republicans did what? They picked up the very exact bill with the same language and introduced it as their way to go after rogue prosecutors. So the checks and balances piece is really hard. Jackie Johnson, ultimately DA Jackie Johnson, has been indicted by the U.S. Department of Justice. She lost the next election to another DA that ran in that community because the community was incensed and said, you no longer represent us, right? And then if she's convicted, ultimately she would be, disbarred and all those things. So I think we have to have a conversation about what are the appropriate checks and balances. And while on the face of it, it seems like going to a commission for that type of incident makes the most sense, you have to ask yourself, if we really want to set up a system, understanding that this is all about politics, unlike the state bar process, and certainly we hope not the criminal justice process, that there is a due process embedded in those systems. You can't just lose your bar license in any state. There's a process. And even if you're charged with a crime, there is a process. This type of commission that was created, there really isn't a process. It is 8 white men, all appointed by Republicans, that sit on a panel that wrote their own rules that get to decide who should be DA and who shouldn't for 10 years. That's not the right level of checks and balances. So we really have to have the conversation about what oversight looks like. And I will tell you, the NAACP, the ACLU, Southern Center for Human Rights, all the organizations that I asked if they would stand up and speak out about this bill, they were like, we're with you, Sherry. We think this is awful what they're trying to do, but we can't get out there and say we don't think there should be checks and balances on prosecutors. And that in lies the problem. Because they understood that what this commission was wrong and harmful to discretion, but at the same time, they also said, but what about prosecutors that are really doing these really unacceptable things in our community?
Yeah. Did Rachel or?
Yeah, I mean, I just wanted to get back to that question that Dean Chemerinsky asked. And I think, yes, it is, of course, I would support any sort of legislation that's sought to stop the recall process the way it exists and to stop governors or attorneys general from intervening. But I think it's important, and I mentioned this morning, that we have to remember that there's solutions that the folks who are trying to attack the reform prosecution movement are using are varying. They're creative. They are innovative. They are using different strategies in different states depending on what they think will succeed. So if you have a state like California, they're going to have recalls. If you have a state like Georgia, you create a commission. If you have Pennsylvania, you create an impeachment process. If you in Florida, you have the governor. So I think there's different strategies. And yes, we can try and do whack-a-mole and try to get rid of some of those strategies individually. But I think there's a larger problem, and I think DA Boston kind of spoke to it, which is the need for those of us who care about protecting the work of prosecutors in promoting criminal justice reform also have to be united and play out of a common playbook too, to protect that role and to ensure that we are able to have prosecutorial independence to promote the kind of discretion that prosecutors have always used but are now using to promote justice as opposed to just promote convictions.
Yeah.
Oh, I definitely think we should stop the recall.
Did you want to jump in?
Can I add one thing to this conversation that we haven't touched upon, which I think is relevant, is the role of police unions?
That's exactly what I was about to ask.
Sorry.
No, you're perfect. Go ahead.
So I think that that's such a huge part of what we've seen in a lot of this in various ways, whether it's Kim Gardner in St. Louis being forced out of office by police unions who were angry at her approach. And so much of it comes down to police accountability, which is an approach that so many reform prosecutors have adopted. And obviously, police have a lot of power, and police unions have tremendous power and money in this country and in most jurisdictions to be able to influence voters in really powerful and influential ways, whether it's through leaking information to the press immediately before, things that it is legal to leak, but to ensure that they can sabotage a prosecutor. And so much of that comes from the desire to not be held accountable when there has been real harm committed by law enforcement. And I think that colors so much of this conversation is a lot of this backlash is secretly being organized by the most powerful union in the country, which is the police unions.
Absolutely.
DA Boston or DA Price, did you want to jump in? Not necessarily about police unions, but just about police political power and their role in scrutiny of the elected district attorney?
The way that I've tried to explain it to my community is that before there was a movement for progressive prosecutors or a clear criminal justice reform movement, and many of us dated from my understanding from when Michelle Alexander wrote The New Jim Crow. And that was a wake-up call to those of us across the country. Hey, this is the next civil rights issue. You better get on board and deal with this. Up until that point, the conversation about criminal justice and the administration of justice and crime was dominated by police and police unions. They're the only people who ever defined for our community what justice looked like. There was no competing, balancing of justice. There was no, people weren't paying attention to wrongful convictions or abuse of discretion. Certainly there was no police accountability. There was no prosecutorial accountability. They were all one big happy family with police setting the narrative and the course and prosecutors tagging along. And the way that I describe it to my community is that this office, my office, belonged to the police unions, and it no longer belongs to the police unions. And we served them notice over and over again. I don't want your endorsement. I don't want your money. I am not going to be beholden to you the way that my predecessor was beholden to you. You are not going to define what justice looks like in this community. Number one, you are not lawyers. And all of us know as prosecutors, they submit the police report and they think because they made a recommendation that this should be the charge, that you somehow are duty bound to follow that. And it's totally false. And what I consistently said to my law enforcement partners that I have to work with and I try to be cordial with is you do your job and I will do mine and we will work together. I will not tell you how to do your job. I'm not going to tell you how many officers to hire or where to deploy them or how many dispatchers we need or, what the contract negotiations should look like. None of that is my business. That's your business. You handle your business. You let me handle mine. And that is a very clear line which allows me to be able to say to them, I'm a minister of justice. I went to law school. You did not. I did not go to the police academy. I'm not post-certified. So don't come and talk to me from we can talk about it, but at the end of the day, as the prosecutor, I make the decision. My prosecutor make the decision. I talked to one of my branch heads right on my way over here. He said, I'm gonna push back on a homicide case because it's insufficient evidence. There's not enough information. We can't convict this person beyond a reasonable doubt. So yes, it's a homicide. It's a horrible tragedy. It may be on the news tonight. And yes, the police union could say, look at what she did. She didn't charge us. Because again, I'm sitting at my desk with a big red phone, right? Taking every call and making every decision about every charge. And so by tonight, they will say, well, she didn't charge us homicide. But he is telling me, for good cause, that there's not enough evidence. It doesn't mean we won't charge the person. It just means you have to do your job, and we're going to do ours. And so you have to draw, for me, it's important as a prosecutor to draw that bright line between the police and the prosecutors. And that is you're absolutely right. Every elected official in America, in my view, is intimidated by the police unions. Everyone, city councils, mayors, everybody is scared of the police union because they have power, they have money, and they have influence over the public. And so, we kind of having that conversation in Alameda County.
I think what I have to add as somebody who teaches rights about the First Amendment is the solution isn't going to be constitutionally to silence the police unions, because it isn't possible, but to instead look for alternative ways to deal with reforming the criminal justice system. I completely agree with everything you just said in terms of how police unions are often a very powerful force against reforming police and against prosecutors doing the right thing. And yet, under the First Amendment, police unions have the right to spend unlimited amounts of money to get the candidates they want elected or defeated. The United States Supreme Court in Citizens United versus Federal Election Commission in 2010 said corporations and unions have the right to engage in unlimited expenditures. They have the right to speak. I don't think I've ever heard of constitutional ways of limiting police unions. And they have the same rights as teachers' unions or any other unions. So there have to be other ways of responding to it. Some of it is courageous prosecutors like District Attorney Price, which she was just saying. Some of it is we've got to have other alternative voices out there to counter what the police unions are saying. And I think the failure has been to develop those alternative voices. And I don't think it's to be silence the unions. It's got to be to empower others to speak.
So I think a piece of this conversation that we haven't touched on yet, because the name of this program is about prosecutor discretion, but really we also need to talk about prosecutor independence, because that is sort of the backbone issue when you talk about police unions and the partnership and the codependent relationship between prosecutors and police. And frankly, that relationship was fine until prosecutors started holding law enforcement accountable for police violence and bad acts on the job. That was the moment that the law enforcement community understood that this person that they relied on to be their person, they now had to worry would be willing to out their bad behavior. And so then it became this issue of now we want to have a say on who is in that office because we want a partner that is going to side with us. And that's the reality of it. And so discretion is as much of a fight for independence as independence is a fight for your own discretion. Because if you are in fact able to assert your independence from all the other actors that on most days are your partner, then it allows you to do the job that your community has elected you to do, which is to hold everyone accountable for violence in your community, even if that violent actor is holding a badge and a uniform. In fact, probably even more, because now that person is asserting authority in your community and abusing that discretion. And they have to be held accountable in order to stop what's happening next. So this idea of discretion is really important because if we take away discretion, then we are ultimately taking away independence. And if you don't have the independent prosecutor, that only leaves a prosecutor that is acting under bias and with other people's concerns at the front of their mind. And that we cannot have.
So I think the last thing I wanted to ask before maybe we move to audience questions is for the prosecutors, is this type of kind of extreme scrutiny of your discretion just endemic to your roles now that they've become sort of more politicized that they'd been in the past? Or are there strategies that you found to avoid that kind of scrutiny or that kind of backlash and or toplash or sort of advice that you would give to someone in a similar position?
Well, it's here to stay, so you got to figure out a way to combat it. And I guess for me, especially as a Black woman, but I was raised as a Black child, and when you're raised as a Black child, your mother, your grandmothers, your aunts, your uncles, your father, they always tell you, you have to do double what everybody else does. You don't have the luxury of doing less. And so while that shouldn't be the standard for me, it is how I was raised and how I understood I had to be to survive in a world that expects me to do just that. And so, I think it's normal for me to think about everything in a way of, well, what will the criticism be in advance and work to produce the data, the evidence in advance. So when they're like, but, I'm like, okay, here, right? That's what we have to do. And that's why, whether we like it or not, that's the standard I'm held to. My white male colleagues, they're not asking them for that data. They're just, they ask them the question and whatever the answer is, they accept. I answer the same question and they're like, well, where are your receipts? So yes, Sherry Boston has to save her receipts, and I do. But that is, for me, as a Black woman, it is not uncommon, nor do I feel like it's anything different than the world that I've already been living in for the last 50 years. But it is my advice to people that are gonna do this work, right? Collect your data, have your receipts ready, prepare your messaging in advance, have a good comms person, and be prepared to back up with facts and information every decision that you make in your office, even if you think it's a small one. That's the reality. It's not going away. It's not going anywhere.
And I'm not an elected prosecutor, but I work with a lot of elected prosecutors. And one thing I just want to say that we haven't really touched upon as much in this panel is the personal attacks that primarily Black women have faced in this role. State's Attorney Fox talked about it briefly. State Attorney Ayala spoke about it as well. But there's an amount of just heroic courage that I see from those prosecutors of being willing to stand there while it's not just, the media attacking you, that that's brutal, and governors trying to remove you, that that's awful, but it's the personal fear, I think, and
It's
the
the
personal
death threats.
It's the death.
That's
it's
just,
literally-
yeah, say what it is. It's the death threats.
Exactly, and the vitriol, and just I don't think that's talked about enough and appreciated enough. What many folks in this room have had to go through, and many others outside of it. And so I just want to commend the courage, I think, that it takes to do this work. And I think certainly there are new strategies that a lot of prosecutors have to adopt. Some of them are really sad, like being less transparent, as we heard DA Boston sort of reference earlier, that some of those strategic decisions need to be different. But I also just want to say that it does take a lot of courage, and I know State's Attorney Fox talks about this all the time, but it takes a lot of courage to be in this role, especially when you're going to face the kinds of personal and political attacks that we are seeing across the country.
I was a well-respected, award-winning civil rights attorney, member of the faith community, and then I became the district attorney, and I became that dangerous person, incompetent, heartless. I represented victims for 40 years. Now they say I don't care about victims. I was a victim. I was prosecuted by the Alameda County District Attorney's Office, but I don't know anything about my office. And it's that kind of personal level that is beyond political. It's part of the season that we're in. This is a fight for our democracy, and it is unfortunate that it's the kinds of attacks that we receive are not unique anymore. They are consistent with everything from the highest office in the land to the dog catcher. People will just say anything. The media will print anything. And so you do have to be able to stand knowing what your purpose is, why you got into it, and know that we are, Kim Fox said a couple years ago, we're not the cure, we're just medicine. And keeping that in mind has been helpful to me to recognize, and I tell my team, we are not the cure, we're just medicine. And so we're trying to heal a sick, very dark system. And most people in our community have no idea how dirty this system is or how dirty politics is. But that's where we are.
Should we, if folks have questions in the audience?
Thank you. You really bring me to tears. And, I spent my life as a defense lawyer, not as a prosecutor, until I started doing this work. So thank you all. I want to deal with Sherry, ask a question. You've asked a key question about the balance between democracy and checks and balances. And, I'm talking about the ABA task force, the best we were able to do is say, have a resolution. You can't remove prosecutors for political or partisan reasons, right? When we look at these removal statutes that exist, they generally say, yes, you can remove people for neglect of duty, for incompetence, blah, 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 blah. As I listen to this and think about the discussions we've had, I think about Dan Satterberg, who one of the original, he never called himself a progressive prosecutor. He was in Washington long before there was such a term. His view is, I'm sorry, I was elected. That should be the answer to this. We shouldn't go back to I'm trying to tinker with statutes to say maybe we should define neglected duty, maybe we should define incompetence, but maybe that's all wrong, and that the position we really need to take is to say, this is about what you were saying at the end, DA Price. It's about elections. You know, we might be electing a mentally incompetent president in this country, right? But we're going to elect that person.
Let's hope not.
Well, I hope not too, but I'm just saying, so it's about elections. Why should it be different for prosecutors? I understand we have this serious separation of powers issue that, Erwin, I don't know if you want to comment on, that we have to deal with, which is this notion, well, governors are elected and legislatures are elected, and so why shouldn't we figure out a system to remove the DA? But maybe what we ought to do is just take the position that, no, sorry, it's really about elections in the end. So I'd like you to...
Right, and I agree with you, Ellen, on that regard, and that's why I went to my legislators and I said, this isn't the way, right? It's also why, at the same time, I went to the Board of Governors and said we need to look at Rule 3.2 and adopt a more stringent policy about special duties of prosecutors and hold them accountable. Because there are certain, again, if a prosecutor is violating the ethical rules, which we are all obligated to follow as lawyers, then they should lose their bar license, which would also mean you can't be DA, right? And I thought that is an appropriate check and balance, right? Because all lawyers are held to the same standard, and it is evaluated in a process that is the same for everyone. So when we hear about like Mike Nifong and Duke back in the day, he was removed because he violated an ethical rule that we all have sworn an oath to do. But it wasn't about removing him as DA. It was about saying you no longer should be an attorney in any shape, fashion, or form. So I agree with you. I think there is, and ultimately the voters, right? If it comes down to the voters don't think you're doing your job, whatever that is, then the voters have a right to have their voice heard at the ballot box. I think the checks and balance systems becomes hard. When Ahmaud Arbery happened, I understood the visceral reaction of members of my party, but at the same time, I understood that that wasn't the right remedy. But it worked out. She's gone through election, and she was indicted for conduct that was violative of the law and found to be violative of the law upon investigation by authorities of the things she actually did to try to prevent that justice in that scenario.
Sure. It goes back to checks and balances. I would be uncomfortable with a system that said that an elected DA cannot be removed during the term of office. There is no way to remove that person but for voting the person out at the next election. I don't think that provides enough of a check. I also would very much favor a system that eliminated the possibility of popular recall of district attorneys and eliminate the ability of the governor to remove district attorneys. Now the question is, what's the standard and what's the procedure? Should the standard be, as was just suggested, only if there is a disbarment of the district attorney? Is the person removed? Is that enough for checks and balances? And what's the procedure? Certainly the Georgia procedure is an unacceptable one. The Florida one is an unacceptable one. But to me, this is the right question of what is the legal standard and what is the appropriate procedure that provides independence for the position, but still some checks and balances.
Hello, how you guys doing? Excuse me. So my question is, I don't know if it's even a question, maybe it's a statement, but my point is this. Pam, you made a point. How you doing, Pam? You made a point about most people not knowing, how dark, blah, blah, blah. The reality is most people in my hood, where I come from, we actually do know. And the problem is, that's why we disengage from this process, because we know how dark, how corrupt it is, and we think, fundamentally, that, hey, man, guess what? We don't care who they elect, they ain't gonna be able to do nothing. And we use you and people like you as examples. Man, look what they're doing to Pamela Price. You see what I'm saying? So why should we be involved in this stuff that we all know is corrupt, it ain't finna change, and white folks is controlling the whole narrative? So why should we get involved? I ain't vote. That's what I'm talking to young people about across the board every day leading up to these elections. They don't want to vote. Not just young people, my OG homies, cats that got out the pen, they don't want to vote because they say, man, the thing is corrupt. So I ain't getting involved in it because it don't make no difference. Vote somebody in, they're gonna kick them out some kind of way if they're trying to do the right thing. So I think that's an issue that you're really gonna have to talk about and address, because all this other stuff you're talking about is cool, but at the end of the day, if you ain't got the votes, you ain't in office. You see what I'm saying? And if you can't get people to come out their houses, out their hoods, to come to do the voting, because they don't believe that it's gonna make a difference, it ain't gonna work. So I think you really need to start thinking about that and how you're gonna start getting to people like me and people in my hood. Because I'm thinking about not voting, to be honest with you. I'm like, man, shit, why am I gonna vote? Excuse my language if I'm saying something illegal, as they say. But really, you need to start talking to people like us to get us to start thinking about, why should I vote? For the president, for the district attorney, for whoever. Because if you don't do that, the people that's on the other side, they engage in those people. All right, thank you.
Yeah, I want to affirm what he was saying. This is a legitimacy issue. And I think that's the question. Dean, I hear you on the checks and balances piece. And what I've said earlier is for hundreds of years, there wasn't a check or balance, right? That the exercise of prosecutorial discretion in these instances that Sherry has described, that you've described, that there are mechanisms by which, as an attorney, right, separate and apart from the oath that one takes as an elected official, there's the oath that you take as an attorney. And the assumption of that is that you are turning over Brady material, that you are not abusing the position. And there are mechanisms in every state bar association by which you can hold attorneys who go afoul of that obligation responsible. And that is different than what we have seen. And my pushback is, it does feel extraordinary to me that in the last 5 years, that all of a sudden there is this need for a check when certain people have the power. And what this gentleman just said, it is about disenfranchisement. That when we do look at where these instances have happened, where prosecutors are being removed and the constituencies for whom they serve, that all of a sudden it is for that individual to say, I don't trust the system. Because the people that I have voted for, whatever narrative has been created outside of like the facts, allows for a system, like you said, whether it's recall, whether it's impeachment, whether it's special prosecutor, whether it's a fascist attempt to just remove people, that is whack-a-mole. Because we are responding to a wholly undemocratic process. And even if we want to find ways, whether that's around prosecutorial immunity, and those conversations, we can have those. But all of a sudden saying a different standard for prosecutors, how do we remove the president of the United States? How do I remove the governor? How do I remove a mayor? All of a sudden, I got a new standard for prosecutors that are different from other elected officials when we're worried about checks and balances. I have a problem with that. And the problem is fundamentally what this gentleman has just said. It is delegitimizing the votes of people who've decided that this is what they want, and the check that is being applied is by people who don't want that. That is different from you are engaging in malpractice, you are engaging in misconduct. And I just want to make sure that we are not conflating the two. People who engage in malpractice or misconduct, there is a vehicle for which to do this. What these vehicles around removal are not about that at all. It is about, I don't like your policies, I don't like your practices, and I want to circumvent this democracy. And if we conflate the two, I think we will do exactly what is being described, which is playing whack-a-mole. And what is happening over there, on the other side that is trying to circumvent democracy, is they are consistent. And the consistency isn't the mechanism by which they're doing it. The consistency is get them out, by hook or by crook. And if we're over here debating, like, yes, we should have checks. We do have checks. We're lawyers. We do have bodies that you can be reported to for going afoul of the law. That's what we should be sending people to. But I think I just will reiterate what I said in my keynote. I find it stunning that the 28 laws or 28 states in the last several years, it has been in a truncated period of time. And when we're talking about issues related to prosecutorial misconduct and the reasons we will want to and need to have a level of transparency on prosecutors, didn't exist 10 years ago.
Does anyone want to jump in?
No one can ever follow.
No. What Kim said. That's it. Drop the mic.
Yeah. I guess I'll just contribute my 2 cents as a political scientist on the issue of top lash or the kind of vehicles to remove elected county prosecutors by state officials that we've been seeing in conservative states all over the country. That, I mean, there are crowds where it's a bit inflammatory to say this. I'm not sure this is one of them. But, I mean, this is very similar to what we're seeing overseas with governments that take a shape of what comparative political scientists call competitive authoritarianism.
Yeah.
Which is that there are free and fair elections in the sense that elections are held on the appointed day and more or less everyone is allowed to vote, and there are 2 parties, but there are extreme intimidation tactics adopted by a majority party that does actually fairly command a majority of voters in the jurisdiction, but that party uses its power in government to intimidate the media, to intimidate opposition party members, to discourage them from running in the first place. And that's where you have a real degradation of the democratic process that I think is really extremely troubling. And that's something that you're seeing in Georgia, Florida, Texas, Tennessee, I mean, all these states that Rachel was talking about. And in terms of, I mean, separately to that, I don't know if there's like anyone who thinks that the direct democracy process in California is not just so broken. That I don't know if there are others in this room who've moved from other states to California, but the Russian novel that we receive for our ballots is just shocking. And the number of state and local ballot measures that we're at, I mean, we pay our state legislators to be experts on all these policy issues, and now we're forced to do all sorts of research on transitions to natural gas and how many nurses there need to be at dialysis centers. I mean, outrageous, like weeds policy stuff. And the recall process is similar. It's supposed to be direct democracy reform, but in reality, all it does is give power to the kind of rich people and businesses that have the money to fund the signature gathering to get these recalls going in the first place. So I don't know if, Erwin, you think that there are kind of reforms that are possible, but it strikes me as just a really, really broken state system.
I agree with everything you said. I think that the system is broken in terms of allowing recalls. We saw it with regard to Chase Dean. We saw the attempted recall of Gavin Newsom. We saw the attempted recall of George Gascon. We see the attempted recall of Pamela Price. I also agree with you about the initiative process. Here's the problem in fixing it. People don't want to vote themselves out of power. People don't want to change the initiative system because they don't want to vote themselves out of having the ability to adopt laws in that way. People don't want to change the recall system because they don't want to vote themselves out of power. So I think the question is, how do we fix the broken system in light of that?
I was just going to say this about California is a very interesting place to me.
To all of us.
To all of us. But I will say this, you know, while I can't imagine getting a Russian novel to vote on election day, I always say, like, when I think of California, there's a little bit of jealousy there because in Georgia, there's almost literally no ballot referendums and no ability for the people to voice except through their elected officials. And if you're elected, and it's not just your individual elected officials, obviously it's who has the majority, right? So I'm in a state where we can't put abortion on the ballot, right? We can't put same-sex marriage on the ballot. We can't put gender-affirming care on the ballot. All of these things that we don't get a voice in. So I will say this, again, I can't imagine what it's like to get the Russian novel before voting, but there is a part of me that's like, the grass, there's good things and bad things on either side. And I think the advantage that you all seem to have with all your propositions, I can't keep up with the numbers. I heard a couple today, I'm like, what is that? But is the idea that it has given you each individual voices in a way that in the state of Georgia, we don't have that same individual voice. So
Yeah.
with the good comes the bad, I guess. Yeah.
Are these final thoughts that we're saying?
Go ahead.
I just wanted to reiterate, I mentioned this morning, State's Attorney Fox mentioned it as well, but this issue is so front and center for a lot of the political landscape that we're in right now and isn't going away. And if you're not familiar, I encourage you to read those few pages of Project 2025 that talk specifically, and just to answer your question in terms of authoritarianism and just the idea that we're going to start suing prosecutors or whatever legal action means as it's used in Project 2025, whether it means criminally prosecuting them or whatever it could mean, I can't emphasize enough how much the playbook keeps changing. So I just want to stress how much this is clearly an effort to disenfranchise people and cause them to feel hopeless and to feel like their vote doesn't matter and that their voice doesn't matter. And it's not going away. And so we can try to attack some of these individual strategies, and we should. And that's why the IIP signed on to the amicus brief that DA Boston is lead plaintiff on. But I also think we have to address the larger problem here, which is exactly as State's Attorney Fox just said, this idea that now that we have people in power who are using new approaches that are data-driven, that are talking about long-term public safety and being responsive to community needs, as opposed to just perpetuating failed strategies of the past, that's when we see this huge backlash, and it is taking multiple forms. And I worry a lot that that's getting lost in our conversation about democracy, that we are losing the ways in which there's this real threat happening, and that it is continuing to evolve into new strategies, and we have to keep our eye on that, and we have to address it head on by being coordinated and strategic together.
Great. Well, I think we're a minute ahead of schedule, but I think that's a good place to end. Thank you all so much. This has been really, really interesting.
Very happy to have our panel stay up. I'm going to do closing remarks. It's a really tough act to follow. I'm so appreciative of this panel, of all of our panelists. I want to just start with a thank you to the people who took time out of their schedules to come travel here, to be with us, the people in the audience, our generous sponsors at the Kecker and Van Ness Law Firm, at Paul Weiss, at Debevoise, the phenomenal work of our students on the Berkeley Journal of Criminal Law, our co-sponsoring organizations. I have learned a tremendous amount. And I have to say, I was resisting the urge throughout today to interrupt and chime in, to jump to the microphone when Q&A started. For me, as someone who has lived so much of this, who's been through it, it's been tremendously stimulating in terms of my own thoughts and ideas, and informative about the kind of work that I think needs to be done. I want to kind of reflect for a moment on where we find ourselves. It's not entirely accidental that we are here just 10 days before an election. And I think it's something that's come up over and over again: politics, elections, the moment we find ourselves and the anxiety that so many of us feel about what's about to happen. And for me as a trial lawyer, it kind of reminds me of that moment when you've made your closing argument and the jury is out and you don't know what they're going to say when they come back. And as anxiety-inducing as that moment is, I remember vividly every single one of the dozens of jury trials I did. I remember the lawyers that I supervised in the public defender's office and the DA's office. And the reality is this moment, that moment, is when we are most reflective and open to criticism and feedback and creativity, because anything is possible. And in 10 days, when we get the results, maybe it'll be longer than 10 days, but when we get the results of all these propositions and local elections and federal elections, there's going to be a lot of Monday morning quarterbacking about who did what right and who did what wrong. And there's going to be narratives that are woven about the criminal justice reform movement, about what voters do and don't want. And so I want to try to take the next 10 or 15 minutes, not to engage with every single thing that every single speaker said that I found provocative, which I'd love to do, but I know it's a Friday night and people have plans. But rather to kind of try and share some of the most significant things that stuck with me from today's conversation, from each panel, and to tell a couple of stories, and try to engage with I think what were so many of the really, really profound comments that folks made today. Becca Goldstein, who just moderated this panel, talked about this term she's coined called toplash. And whatever happens in the elections, there is going to be a narrative about criminal justice reform being dead, about voters no longer wanting it. And it's so critical to remember what her research shows, what the experience we just heard recounted by so many elected officials, by so many district attorneys, and folks who've been on the front lines, that it's much more complicated than that. It's much more nuanced than that. That often the folks pushing back the most aggressively are not voters at all, but traditional elites. I think Dean Chemerinsky's comment a moment ago about checks and balances is also a really critical one. And it's one that can be difficult in the moment for those of us that feel a partisan allegiance to a particular cause or a particular elected official or a particular outcome to recognize. And particularly when we're under attack and when we don't have the power that we want or that perhaps we deserve after an election, to recognize the need to also build long-term checks and balances, as he talked about, to have certain frameworks in place that can ensure no matter who's in that office, the power is not being abused. I want to give you sort of a concrete example of how I think this is a really difficult issue. There's a new law that came up a couple of times today. It's called the Racial Justice Act in California. And one of the teams of amazing students that I've been working with here at Berkeley have been doing a research project looking at district attorney policies. The ACLU requested all the policies that every DA in the state has, 58 counties. And it was a multi-year process to gather those policies, and now a group of students have been reviewing those policies for over a year. And they're examining the policies through the lens of the Racial Justice Act to try and identify policies that might either ameliorate or exacerbate racial disparities, that could be a basis for either a claim a defendant could file or could be a model policy to encourage other prosecutors to emulate. And there's a case that it came out of the Bay Area maybe a year ago now, year and a half ago, where a gang enhancement in a murder case was dismissed by a judge. And one of the bases for, under the Racial Justice Act, and one of the bases for the judge dismissing that gang enhancement was not the kinds of things we've been talking about today, where prosecutors implement a policy and then they're attacked by the state legislature or the governor for what that policy is, for that presumption not to charge enhancements, for example. But it was in fact the absence of a policy that the court pointed to. I was talking with John about this earlier today, and the dilemma that especially a small office with, say, 2 or 3 attorneys would have, where if you don't have a written policy that provides instructions, a written policy that could say everybody who meets these criteria is entitled to this diversion program, or we have a presumption against charging enhancements, then if the reality on the ground is disparate impact, at least under California's Racial Justice Act, your charging decisions could be subject to scrutiny and to reversal. So it's an example of where having policies can both be problematic and expose us to attack, where those policies could, in many instances, say we're not going to exercise our discretion to ever consider mercy, or on the other hand, the absence of policies could allow implicit bias to control. I think these are really complicated problems to solve, and it's particularly challenging to do so in a context where our allies, where our heroes, where the people whose shoulders we're standing on are being attacked, are receiving nooses in the mail, as State's Attorney Ayala described. It's particularly difficult to think about building the kind of constitutional structures and frameworks necessary to ensure and protect the kind of independence and discretion that have been an absolute hallmark of elected prosecutors throughout this country's history until, as State's Attorney Fox says, 5 years ago. You know, the immigration panel is one of the panels where I felt kind of an uncanny personal connection. And I could say this in some ways about every panel. I mean, I've learned from and been inspired by. I wouldn't have run for office quite literally if it weren't for State's Attorney Fox. And so many of the people here worked with me, taught me. I'm looking at people who I learned from tremendously in my early days in office. But on that panel, I mean, Lucas Gutentag taught me immigration law. So I want to echo what he said, which is that everybody going into this field should study immigration law. My first job at the San Francisco Public Defender was to create an immigration unit there on a fellowship. And that unit and that work was inspired by the work that Raha has done in Alameda and had done previously. I never met her in person, but I talked to her on the phone and I studied her work. I want to interrupt myself and just say a part of the reason I'm going through this is because I think it's so critical for the students in the room and in the audience and on Zoom to remember that the relationships you build today as students, the people that you meet, sometimes the people you go up against in court, are people with whom you can and should seek to build lifelong relationships, who you can learn from in unexpected ways, whose lives and careers will intersect with your own at moments that you can't predict or anticipate, but which can be critically informative in terms of the direction you go and the impact you're able to make. David mentioned a case he worked on at the Brooklyn DA's office that involved somebody I knew. And I want to just tell that story in a little bit more detail than he did. And I think probably he was circumspect out of respect, out of the privacy of the individual. This is someone who I've known since I was a child. And I think the story really illustrates so much of what we're talking about here today in terms of discretion and the power of discretion and the need to have people who will wield that power in ways that are just and merciful. The young man that he mentioned was somebody I first met in a prison visiting room when I was visiting my mother and he was visiting his mother. And this young man's name is Lorenzo. He was a couple years older than me. He was born in Guyana. He came to this country when he was a couple of years old with his mother, who ended up serving decades under New York's Rockefeller drug laws. And for those who don't know, they're a kind of quintessential example of the excesses of the war on drugs. Like so many children with incarcerated parents, I had a lot of anger, and I had a lot of challenges as a kid. But Lorenzo was a role model. Lorenzo was a straight-A student. He was winning writing contests statewide as a sixth grader. He was the star of the basketball team. When I would misbehave in the prison visiting room, my mother would often say to me, "Can't you be more like Lorenzo?" Or in other instances, when I would go and hide in the prison visiting room bathroom so that my mother couldn't come and talk to me, and I would watch the clock tick by, she would send Lorenzo to talk me down and come back out and finish the visit with her. And this is all in the pre-Facebook, pre-internet era, right? And so over the years, Lorenzo and he lived in New York in an immigrant community in Brooklyn. He was black. I'm white, obviously. I moved to Chicago with my adoptive family. We stopped visiting our mothers on the same days, and we fell out of touch. And it was my freshman year at Yale that I received a letter in the mail from my father, who was still incarcerated at the time. And my father said to me, I just met somebody on the prison yard who says he's a friend of yours, and his name is Lorenzo. And it forced me in that moment to really reflect on not only the privileges and the opportunities that I had had related to my class and my race, my immigration status, but also on the human potential that is being wasted every day in our system. Because I knew, even though I hadn't talked to Lorenzo in years at that point, I knew that he had every single bit of potential that I had. And I was at Yale and he was in jail. I knew that he had the ability not only to get an education, not only to write compellingly, but to have a profound positive impact on his community. So I went to visit him, and I'm not going to tell you the whole story. I went to visit him in prison with my dad. He pushed back on some of what I think at the time were relatively naive perspectives that I had about the different paths our lives had taken. He wanted to own personal responsibility for his choices and the mistakes he'd made. He didn't want to be limited to a statistic or data about racial bias. He wanted to recognize that he'd made some bad choices along the way. And I went to visit him again when he was released from prison and transferred immediately to immigration detention, and tried hard to fight his immigration case, to find him pro bono counsel. Lorenzo ended up getting deported to Guyana, and he'd never been there since he was 2 years old. I went to visit him in Guyana. That's the kind of friendship that we had. I actually helped him start a small business there just to make ends meet, to survive. He was living in a house with no windows, open air. And over the years, he fought his way up. He moved to Trinidad. He started a construction company. I stayed in touch with him. He married a U.S. citizen. He became a father to her children. And at some point along the way, I was talking to a friend of mine from law school who was an immigration lawyer at the law clinic at Cardozo. And we reached out to Eric Gonzalez's office. and D.A. Gonzalez assigned David to work on the case. And they started looking at Lorenzo's criminal history. One of the cases was when he was a juvenile, one right after that when he was an adult. And as David told me, they realized that the punishment was far in excess of anything that was proportionate to his role in these crimes. And they worked with the immigration lawyers for post-conviction retroactive relief. And something extraordinary happened that those of you who practice immigration law will know never happens, which is that the immigration lawyers for the federal government didn't simply agree that they would withdraw opposition to Lorenzo seeking to get his green card back. They affirmatively joined his motion in asking the court to give him his green card back. Lorenzo has now spent time since he came home and is living in Brooklyn with his family, not only working to earn his college degree because he wants to go to law school, but he spent time working as a violence interrupter in Brooklyn in the very community where he was arrested and prosecuted, in a grant that's funded in part by the DA's office. So when we talk about discretion, D.A. Gonzalez didn't have to do that, just like the tough on crime prosecutors decades earlier didn't have to prosecute Lorenzo and send him to prison. We have tremendous power. And I want to encourage each of the different groups that I think are represented in this room, as my time runs short, to think about how we use that power, because the jury is still out. Not just on this election, but on criminal justice reform as a movement, on progressive prosecutors as part of that movement. The jury is out on whether or not the legal profession, for all of you students, can play a positive role in redeeming our collective humanity, restoring faith in our democratic system, giving people like Lonnie a reason to vote. After all the years he spent in prison, to hear him say that he might not vote in this election should be a clarion call to all of us that we as members of the legal profession have to do more. We have to do more. We have to do better. And for the students, look at the people on stage today. Look at what they've accomplished. And remember what Jody Linker said about getting punched in the face and getting right back up and never taking no for an answer. Because the attacks, the opposition, the entrenched systems of power that so many of you chose to come to law school to change are well-resourced, and they're relentless. And as Angela Davis said when she sat on this stage a little over a year ago, right after we created this center, nobody should expect that the path to victory is going to be linear or easy, that it's going to be without its defeats along the way. To those of you in office, some of you just for 37 more days, some of you for longer, depending on how elections play out, I would also say, remember that as an elected official, you are constantly walking a tightrope between being a representative of the people in your community. Some of those people are people who think the death penalty is an appropriate response to shoplifting. And on the other hand, a leader. And I would encourage all of you, as you have done for so many years, to continue to lean into that leadership role, to continue to inspire, because you cannot control whether or not you get to serve out the remainder of your term or who replaces you once your time in office is done. But what you can control is how you look back on your time in office. And you can make decisions in these few days or months or years that you will always be proud of. And I say that from experience. You cannot control when you leave or what comes next, but you can control the dignity and the integrity with which you lead. And finally, to the scholars, because I know we have many of those in the room as well, I would say to you, continue pushing the boundaries of our understanding of the legal system. Continue educating the next generation of prosecutors and defense attorneys and judges. But also I want to challenge you to do more than just educate the people in your classroom or the other scholars who read and cite your literature. I want to encourage you, as many of the folks who we had the privilege of hearing from today do every day, to think more broadly and ambitiously about your work. And when we hear conversations like the last panel about the misinformation in the media, about the misunderstanding of the role of the prosecutor, it is impossible for elected officials who are under the kind of attack that so many of our speakers today are under, for them to be the ones to step up and correct the misconceptions. It's impossible for them to set the record straight when every single charging decision is being scrutinized in a way that never happens to traditional prosecutors. in a way that's misunderstood and misrepresented by the press. And so I want to encourage the scholars in the room to lean into the role that you can play in a unique way of increasing the nuance of the conversation in the public square about these issues, at a time when there is so much misinformation and disinformation, at a time when there's so much confusion about democracy and about the right to vote and about criminal justice reform and how we even understand public safety. We all have but one life to live. And in many ways, the jury is out on our lives until it's too late. And so let's lean into that moment when we can be most self-critical, most inspired, most proactive. Let's approach the moment that we're in, not just these next 10 days, but beyond that, with the urgency that it desires. And let's find ways to continue to lead and to inspire and to make the legal system a system we can truly call just. Thank you.